Mr. Mayor. Before I take your lordships and your ladyship back to section 41.4, I just wanted to say something about my written case. And you may have gathered from my submissions in the 15 minutes before the break that I am conceding something that I didn't concede in the written case. And in the case, I did argue that the courts could have considered the matter in the round, consider both phases at once. And I deployed a causation argument to say that the court could have found, and this court could have found that a deportation order would have been made in any event. But when I came to look at that again for the purpose of this hearing, I realized that runs into Lumba and Kambadzi. I can't rely on causation to make the period of detention unlawful. Because as the Supreme Court said in those cases, if as a result of a failure to follow a lawful procedure, a person's unlawfully detained, it's no answer to that to say, well, if the lawful procedure had been followed, they would have been detained anyway. Now, my learned friends spotted from me putting in Lumba that Lumba also invites the question whether causation is relevant to compensation. But I'm not going to invite your lordships to find that a deportation order would have been made anyway, so that Mr. Ngumi shouldn't be compensated for those 3 months more than nominally, because I accept that's a new point, and I accept that it would require findings by the board which weren't made below, as to specifically whether a deportation order would have been made and whether Mr. Ngumi would have been detained under the power that then was exercisable under the authority of the Governor-General. So Mr. Smith can stand down his worries on that front. So that's just explaining where I differ from my written case.
But may I say, be clear in my mind, but you're not conceding that more generally. You're just for this case because it hasn't been taken up to.
Yes, not more generally.
Yeah.
If the point had been taken below, and if the courts had found, well, of course, a deportation order would have been made, and of course, Mr. Ngumi would have been detained as a result, then the Lumba argument would be that only nominal compensation would have been available, at least for the reasonable period.
So at least for 6 years?
No, only for what would have been a reasonable period.
For the 3 months, or
yes.
whatever.
Yes, and then you would be able to say what would have been a reasonable period rather than what's actually being done. But that's the compensation argument rather than the lawfulness argument.
Yeah.
So there's a difference. So I'll leave that, and I'll move on to the power of the magistrate to make recommendations. Make the recommendation, and I do. My submissions are those which follow the questions put to my learned friend by my Lord Sales and my Lady Simler. But just to go to the section itself, which is page 1041. So yes, as we're in agreement that there are 2 limbs to subsection 4, and there's a power of detention in 2 circumstances. The first is after a deportation order has been made by the minister, and the person may be detained, and the second is where a recommendation for deportation is in force, the person shall be detained until the Governor-General makes a deportation order. Now, I would say that last reference to the Governor-General there, where the Governor-General makes a deportation order, is actually an anomaly of drafting, because the power to make a deportation order is the minister's. I would suggest that is an anomaly of drafting. It should really say the minister there. But it may not be material in this case because no deportation order was made. And in terms, for the purposes of my submission, that for at least a day or 2, the detention after conviction is lawful relies on a magistrate's recommendation and not upon a deportation order. And as to the power to make the recommendation, I submit it does follow from the words of section 41.4 that one body at least that has the power to make the recommendation is the court upon conviction of for an immigration offence or another offence qualifying under section 40 subsection 1b. Because of those words that appear there, where a recommendation has been made, the person shall be detained unless the court, in a case where the person is not sentenced to imprisonment, otherwise directs. So one of the circumstances where the possibility of recommendation exists is where the court is sentencing the person, and that must be, I suggest, sentencing in respect of an offence relevant to section 40, subsection 1b. And that's the point that's already been made in oral argument this morning. But I would add, if detention depends on whether the court has directed release, in the parenthesis there, that implies that the court must be directing its mind to the provisions of section 41.4. Which rather suggests that it's the court that's the body that's deciding whether to recommend. I think that's all I would add to what was said this morning, other than to go back to the case of Xavier, which was at 1290.
Sorry, and just very slightly to expand on that last point that you made on section 41.4. I mean, the court may be acting at a time when there isn't a deportation order as defined in section 40, subsection 1 in place.
Yes.
And so it's almost the first actor for relevant purposes.
Indeed.
When it has to confront that situation. And yet, as you say, the words in parenthesis are contemplating that the court is deciding whether to direct that something shouldn't happen.
Yes. I suppose one might add, one might ask how the conviction would come to the attention of the minister under section 40 once a conviction has been made. Maybe with immigration, with a conviction for an immigration offence, the immigration division knows about it and the immigration division could bring it to the attention of the minister. But in respect of other offences, where there's no immigration involvement, one asks how would they come to the attention of the minister? Unless by order of the court, or by direction of the court, or recommendation.
Are you going to assist us in relation to section 40, subsection 1c, and the submission made in relation to that?
I will accept that might be a candidate for circumstances in which a recommendation might be made, but on the reading of section 41.4, it's certainly not the only candidate. And section 41.4 clearly, in my submission, implies that a recommendation can be made by the court on conviction, and a relevant conviction under section 40.
I mean, it did seem to me that there are other points as well against it being the board that recommends. So if one looks at the setup of the board in sections 5 and 6, the board is a very high-level body. It's chaired by the Prime Minister. The idea that the board would be making recommendations in day-to-day cases doesn't seem very realistic. And also, as I think Mr. Smith accepted, it's not a function of the board, as defined in section 6, to make recommendations.
My lord, you've gone further than me. All I was looking at is the magistrate's power, and I must admit, in my thinking, I left it open whether the board might, but I...
Yeah, anyway, I just raised those points. Mr. Smith can address them in reply if he wants to.
So I just turn to Xavier just to see what, because I say effectively Xavier is, if nothing else, confirmation that my reading of section 41.4 is how the courts have understood it in the Bahamas.
Slightly odd that, given there were amendments or the provision was reenacted, nothing was done to reflect the problems identified.
I might say that the transposition suggested by the judge in Xavier doesn't really help understanding much anyway.
No, it doesn't.
It's the other matters in section 41.4 that really tell you. But apart from that transposition, I just draw your attention to the paragraphs before, paragraph 24, which is at 1293. Because the judge simply says, without, and we take it up from, I hope I don't need to, perhaps I don't need to explain the circumstances, but the submission was that there was no chance for these applicants to pay a fine and thereby release themselves from imprisonment. That's the context in which the judge goes on to make these observations about the power to detain as a result of recommending deportation. But the simple reason that I draw attention to paragraph 24 is just when one reads through and goes over the page, you'll see that the judge remarks that the magistrate had recommended deportation in each case. If nothing else, it's confirmation that this is how the section has been understood, and that did not cause the judge in that case any problem or concern or doubt that that was the right way to read the section. Now, just so finishing off on the 3 months point, I've conceded that detention was unlawful for most of those 3 months, apart from a day or two at the beginning. So the question then arises, what should the result be? And I would submit, if that is all that your lordships find to be, and your ladyship find to be wrong with the Court of Appeal's judgment, as I submit it should be, then there would be no need to remit this question, compensation for 3 months, back to the lower courts, because an additional 89 days or maybe 87 days on top of the 2,300 days awarded by the judge in the Court of Appeal is just under 4%. And to put that in the context of the Court of Appeal's award, 4% of 750,000 is $30,000. And I submit 4% is the kind of adjustment the board can readily make without needing to remit to the lower courts.
It does, however, lead to a conclusion, doesn't it, that all or a substantial part of the very early period of detention was unlawful. And there is at least some judicial thinking that the early period is of particular importance, hence tapering.
Well, yes.
And the shock effect.
Yes. But this isn't on any view, this isn't an initial shock case, because the judge found that the first 2 days of detention were lawful. Mr. Ngumi was lawfully arrested on the 12th. That's the judge's finding. He was before the magistrate on the 18th. And the judge found 6 days was unlawful.
Should have been 48 hours.
Should have been. So she found 4 of those days were unlawful, the last 4. So she also found the first 2 days were lawful detention. That finding is not in dispute in this appeal. So this is not an initial shock case. And when one looks at the authorities on initial shock, what they do tend to talk about the first few hours, first day or two.
And this person had been found guilty of an offence.
Yes.
He pleaded guilty to an offence which properly could lead to a deportation order being made against him.
Yes, it could have led to imprisonment as well. Sentencing.
And indeed, having been sentenced for an offence of being an overstayer, it was perhaps to be expected on his part that deportation might well follow with a period of detention to allow that to happen.
Indeed.
I mean, he obviously couldn't predict that nothing was going to be done about it by the authorities.
No.
Your primary submission would be that it doesn't need any adjustment then in terms of award.
Well, it's different. Well, I have to accept it's different.
Yeah.
But one might say that one court presented with 6.5 years and one court presented with 6 years and 9 months might treat them the same. But we know that the Court of Appeal and the judge made their awards on the basis of 6.5 years, and I have to accept that 3 months is more.
Yeah.
It seems realistic. 3 months detention, unlawful detention, isn't a mere bagatelle.
No. But in the context of the overall award, it's a minor adjustment.
And one that we
Yes,
could
I
probably
say
make.
your lordships and your ladyship could make that adjustment. So turning to general damages. So in summary, I will be submitting that the Court of Appeal made no error of principle, and there's no reason for the board to cast aside its normal reluctance to interfere with the local court's assessment of damages. And I say that the appellant is not putting forward a principled approach and not putting forward any principle which demands that the board should override the strong views of the local courts in this case. So I know I don't need to take the board to examples where you've expressed your reticence about interfering with damages awards of local courts, but I would go to the Scott case in the context of the Bahamas, just to make the point that the general appellate reticence in relation to damages is overlaid by the further factor that the local courts are best placed to determine the levels of awards. That's what the board said in Scott, which is a case of 1868.
That's a page, not a year, is it?
That's a page. 2017.
Thank you.
This was judgment of Lord Kerr.
Yes, this was looked at quite closely in the St. Helena case, I think, recently, wasn't it? And followed.
Yes, I believe so.
Yes.
1877, turning to 1877, paragraphs 28 to 29. Well, there you see simply a classic statement of the general appellate reticence in relation to damages, citing Nance in British Columbia. But also, at the beginning of paragraph 28, as has been observed at 25 above, there's a reference to the Bahamian factor, and again, turning to paragraph 29, as has been said at paragraph 25 above. So I'm going over the page now. As I read through paragraph 29, I'm just going to emphasize the last sentence. As has been said at paragraph 25 above, this is primarily a matter for Bahamian courts, familiar with local conditions and the hopes and aspirations of the society which they serve. And the reference to paragraph 25 above just begins at the bottom of page 1876. Very last couple of lines of page 1876. Local courts remain best placed to judge how changes in society can properly be catered for. Guidelines from different jurisdictions can provide insight, but they cannot substitute for the Bahamian court's own estimation of what levels of compensation are appropriate for their own jurisdiction. So, general reticence overlaid by the acknowledgement that the local courts are best placed. And in terms of the reasons for appellate intervention, I would just add one more citation from authority, and that's because I would say it might be said that there's even more reason for deference to the lower court in the realm of damages for unlawful detention. It being peculiarly lacking in guiding factors. At least that's the way Mr. Justice J put it in AXD. That's 1690 is the beginning of the case. And 1698 is the paragraph 34. Precedent cases shouldn't be regarded as providing any clear framework. These cases are fact-sensitive, and although consistency in judicial decision-making is important, the evaluative exercise in this domain must be even less precise and even more of an art within the realm of, say, personal injury damages. So turning to damages in this case, the appellant was and is contending for awards of damages that the local courts found to be fantastical. And the judge's finding in that regard is at page 133, paragraph 88. The judge found $3 million compensation to be nothing more than a fantasy. The Court of Appeal used similar terms at paragraph 60. At
Paragraph what, sorry?
page 376, paragraph 62.
Thank you.
Sorry, yes. That's when the President says, "I've no doubt that the sums claimed by the appellant are simply without any merit whatsoever and are in fantasy land." Now, the appellant's submission, as it was below, is that principle demands the figures that he's contending for. And he says, "Your lordships and your ladyship ought to override the strong objections of the local courts because principle demands it." He says that principle requires one to take an initial daily rate from local cases of false imprisonment for short periods of detention and multiply that rate by the number of days in detention. And if one does that, he says, one will get a daily rate of $5,000 or more, and one will get, for long periods of detention, awards in the many millions of dollars. But my answer to that is principle does not demand that result at all. I make 5 points in support of that, and the first is by reference to the decision in Takitota. And that's the board's previous decision on damages for a long period of detention in the Bahamas. It's at page 1891. I believe this point was made by my Lord Richards this morning. In fact, paragraph 17 at page 1900, which is where Lord Carswell sets out the task of the court. Lord Carswell is not there saying that the court must take a daily rate and extrapolate. It says the court should bear in mind, or to take into account, that any figure they might regard as appropriate for an initial short period, if extrapolated, should ordinarily be tapered. So it's not an injunction always to take a figure and multiply. And rather, as is said at the beginning and at the end of the paragraph, the aim of the court is to reach, well, let's look at the last sentence. The final figure for compensatory damages should therefore amount to an overall sum representing appropriate compensation for the period. So that's the aim of the court, to reach an overall sum. And no requirement to use a multiplier approach. The second point is that in this very case, the Court of Appeal of the Bahamas has rejected the multiplier approach. We take it up in the judgment at paragraph 23, page 359.
Sorry, paragraph 23.
Paragraph 23.
Yes, got it. Yeah.
The Court of Appeal's views on the mathematical formula approach are set out from page 359 onwards, beginning at paragraph 23. So here, citing with approval a judgment casting doubt on the mathematical formula, then over the page at paragraph 24, finding the judge was wrong to adopt a mathematical formula, and then lengthy citations from the judgment in Guichard, upon which the Court of Appeal invited submissions, and the judgment of the Trinidad Court of Appeal in Millet and McNichols, which was referred to in Guichard. And then citing with approval at paragraph 27, another judicial rejection of a mathematical formula. So what I would say is the Court of Appeal's taken a view on a mathematical formula and very clearly rejected it. And I submit that decision was open to the Court of Appeal and is, in ordinary circumstances, the Court of Appeal's decision on policy and guidance with respect to the calculation of damages. It's a matter for the local Court of Appeal, first and foremost.
I wasn't quite sure in the lengthy quote from Guichard what the court in Guichard was saying in paragraph 38.
I agree.
Because it's difficult without seeing the whole case, no doubt, but they seem to be saying you should take an initial figure. Having cited paragraph 17 of Lord Carswell's advice.
It's the bit that's not underlined.
It is, yes. The two-step process, I'm not quite sure.
Yes, they say there's a two-step process, but I don't think they are to be read as saying that the second step is a mathematical formula process.
I see. I mean, difficult to know what they're endorsing, I guess, without seeing what Chief Justice de la Bastide says. But
well, that's below. That's de la Bastide in paragraph
below.
26. So
I
that's.
Anyway, I guess the real question is, what does one take out of paragraph 17 of Takitoto?
Yes, I say one takes out of it that one may use the mathematical formula, but one is not required to. And the Court of Appeal, considering that and considering the submissions that were made to it in this case, said, we don't like the mathematical formula. the third point I make is that the third point I make to say that the appellant's submissions are not principled is that when multiplying a daily rate, one reason that the courts give for tapering awards is to ensure that they remain proportionate to other damages awards. And that can be gleaned from the case of Thompson, relied upon by the appellant. And Thompson is 1,922. And this is really relied upon by the appellant as the source of the method. And that was the case where the Court of Appeal was giving guidance to juries in England on the assessment of damages for false imprisonment. And the particular guidance relied upon by the appellant is at 1935.
1935.
Yes, 1935. It's item 5, which is D on the page. So the appellant relies upon that passage for the 24-hour award of $3,000, which he says in Bahamas would be $5,000. But what the Court of Appeal said is that when advising juries to taper, is that the sum should be on a reducing scale so as to keep the damages proportionate with those payable in personal injury cases, and because the claimant's entitled to have a higher rate of compensation for the initial shock of being arrested. That makes the point that I made earlier, that initial shock, we're talking in hours, because it tapers even over the first day. But the point for present purposes is that if one is to use the mathematical formula, one still is enjoined to come up with a sum that's proportionate to other damages awards. And so I say the appellant isn't following that principle when he contends that the guidance results in awards that the courts in the Bahamas found to be fantastically disproportionate.
I mean, is there any evidence anywhere in these papers of the sort of damages being paid for personal injuries in the Bahamas?
No. But I submit that the court's reaction...
Are they still following the
JSP guidelines?
college guidelines?
I can't say, my lord. I would submit that the court's reaction to the appellant's submissions, these are fantasy land, tells you what idea they had about what a proportionate award would be in the Bahamas.
Presumably the judges would be familiar with
Indeed, exactly.
personal injury awards in the Bahamas.
In Scott, the use of the JSC guidelines was upheld, wasn't it?
Yes, because it happened to coincide with...
Because they happened to have done that, not because it was inherently right.
Yes.
But because that's what the local court had decided, and,
Yes.
and the Privy Council wasn't going to intervene.
On the basis that the court was entitled to find that in this instance it coincided with local expectations and standards.
Scott was in 2017.
17.
So until quite recently, at any rate, the Bahamian courts, we can assume, can we, that the Bahamian courts were following the JSC guidelines in relation to personal injury.
It must have been broadly proportionate.
Yes. I mean, that just gives you some sort of benchmark.
Yes.
May not be much help, but it's better than nothing.
But for what are you awarding personal
Well,
injuries for?
I know that does beg the question, my lady, yes. But my primary reliance is on the reaction of the judge and the Court of Appeal to these awards.
Yeah.
And the fourth point I make is the appellant's approach is not principled for this further reason, because he would apply to long-term imprisonment a daily rate gleaned from short-term cases. And these are cases where more than one wrong is being compensated, because all of the cases relied upon by him include false arrest and the initial shock of unlawful imprisonment. And that's not this case. And some also include assault and battery over a short period. But the main point I'll make is in none of those cases did the judge purport or profess to be setting out a general daily rate for cases of unlawful detention. And so I say there was therefore no error by the Court of Appeal in rejecting them as a basis for calculation. And finally, the fifth point. The appellant's own submissions accept that multiplying a daily rate could be a wildly inaccurate method for arriving at an appropriate figure for overall compensation. And there are many examples. I'll take the example of the submission after the appeal hearing, when the parties were invited to make submissions on the case of Bouchard. The appellant's submissions are at 283. And the particular section I'm looking at is 290 begins the appellant's submissions on the approach to tapering.
Sorry, where is it?
So page 290, which is paragraph 11, that's where the appellant's submissions on the approach to tapering begin.
Right.
But the particular part I would ask the board to look at is at paragraphs 15, the appellant's approach to adjusting the calculated figure is at 15 and 16. So, the appellant says he set a daily rate, he multiplies it by the days, he says the mechanistic figure would approach $12 million. And then it's accepted the figure must be viewed in the round. And the actual award sought by the appellant over the page is $3 million. And that's what was always the appellant's case before the judge and the Court of Appeal. The supposedly principled calculated figure for compensation would be at more than $10 million. But he only ever asked for $3 million. He asked the court to award $3 million. Now, in my submission, there's no principled relationship between here, the $12 million, and the $3 million sought. The $3 million is simply the highest figure the appellant thought the court might be persuaded to agree was an appropriate sum overall to compensate him in the circumstances of the Bahamas. His case was always, therefore, an acknowledgement that the overall award has to be set at a level the court finds fair and appropriate and proportionate. And I submit that's exactly what the Court of Appeal itself did in this case. That's exactly the assessment the Court of Appeal made while rejecting the appellant's sums as fantastical.
Can I just check? Did the appellant seek to raise any argument to show disproportionality or a mismatch between the amounts awarded by the judge and whatever scale of personal injuries compensation might be? Okay.
So I summarise that by saying that the appellant's supposed principled approach is not a principled approach which demands that the board override the views of the courts below. As for specific errors relied upon, I submit there is no error in relying on the figures from Takitota. The Court of Appeal expressly said that they were no more than useful guidance. That's paragraph 50, page 90. No, sorry, I beg your pardon. That's where, I'm sorry, that's where the appellant offers it as useful guidance. I'm sorry. I've got my references wrong. The appellant himself offered Takitota as useful guidance. The Court of Appeal's decision...
Sorry, what was the paragraph for the appellant offering it?
Paragraph 50, page 90.
I'm so sorry. Is that in the court, referred to in the Court of Appeal, or when you say paragraph 90?
Paragraph 50, page 90, I thought I was giving you the reference for the Court of Appeal, but I was wrong. That's the reference to where the appellant offered Takitota as useful guidance to the court.
So is that in the appellant's skeleton argument for the Court of Appeal? Is
Before the judge.
Before the judge or the Court of Appeal?
Before the judge.
Right.
The Court of Appeal reference, I'm sorry, I'm just going to have to go...
Paragraph 32, I think.
Oh, thank you, Mary.
365.
365. Yes. Yeah. So, they're simply the last sentence, they're simply guidance that assists a court. And I say it is fair to say that Takitota was guidance, because although the sum that was eventually awarded in damages was a settlement sum, the agreed sum of $500,000, the case before that had gone up to the board on awards, on a calculated award of $700,000 that was then tapered down to $400,000. And the fact that the Court of Appeal was deciding between those two awards the first time round in Takitota.
Well, why do you say deciding between those awards?
Well, it made a calculated figure. It made a calculated figure of $700,000 and then decided to taper down.
But that didn't stop the Court of Appeal saying both were inordinately low.
No, the Court of Appeal said the Court of Appeal plainly found neither to be inordinately low, and the Privy Council did not say that they were inordinately low. The Privy Council sent it back on the basis that the basis for the calculation started from an error, and so there was no discernible basis for the figures that were awarded. They were invited to find that the figure was inordinately low. They did not take up that invitation.
I'm so sorry, my fault. I didn't get a note of what the figure was when, as awarded by the court before it went to the board.
I'm sorry, it was $400,000.
All right,
they calculated the sum at 730, and they tapered. And there was an argument before the board that $400,000 was inordinately low, and the board did not so find. Plainly, the Court of Appeal had not so found. And so the Takitota is useful guidance in my submission for the general region, and which is all that the Court of Appeal took it to be.
I think the Privy Council said it was insufficiently secured on the facts.
That's right, because the initial basis for choosing the daily rate was an error.
So the decision of the Court of Appeal in Takitota was insufficiently reasoned. So the figure that it came up with is not itself a good guide, because we don't know what went into the reasoning. And then it settled.
Yes, at 500.
So, I mean, in that state of affairs, I'm not quite sure what Takitota does tell us about what an appropriate figure should be.
It tells us that the figures in Takitota were not considered to be inordinately low.
Well, the point wasn't reasoned through. It wasn't, I mean, the fact that something is not inordinately low in 2005 doesn't mean that it's an appropriate figure, still less in 2020 or whenever this was decided.
I accept that.
But in the context of the board saying, look, it's not our job, it's the local court's job, so long as they get the legal process right and give proper reasoning. The mere fact that the board didn't say 400,000 is obviously too low, maybe just as much explicable from reticence as it is from any perception that it might have been okay.
Perhaps so, my lord, given that the board was expecting the figure to go and be recalculated. I accept that, yes. All that said, the Court of Appeal was still entitled to look at Takitota and look at how the figures were arrived at and decide whether they were in the right kind of region to compensate for long-term periods of imprisonment.
And the Court of Appeal seems to place some weight on Guichard as well. I'm looking at paragraph 37 now for the figures. Can you just help us with what had happened in that case and what the reasoning was in that case?
I would not be pushing any of the foreign cases as direct comparators.
Well, Guichard's Trinidad.
I think it was St. Lucia, it's Eastern Caribbean appeal.
No, it's the Court of Appeal of the Eastern Caribbean.
Yes, I think the original jurisdiction was St. Lucia, but I may have mistaken that.
Okay.
I think but the point I would make about the foreign cases is they are not there as direct comparators. The Court of Appeal was presented with the argument that the principal way to approach this task of long-term detention ends in figures an order of magnitude larger than it was expecting, than it would have accepted on its own, in its own jurisdiction. And there being no comparators in the Bahamas other than Takitota, I submit it was a fair and useful cross-check to go and look at awards in other jurisdictions to see whether they are in the order of magnitude contended for by the appellant, in the millions, that is, or whether they are an order of magnitude less, in the hundreds of thousands, or even two less, in the tens of thousands. That's the usefulness of the foreign cross-check in my submission.
Might another approach be to identify all the different elements that one must take into account, and to consider by reference to different elements what is a reasonable sum in relation to detention of this kind? The difficulty at the moment is that many of these submissions seem to be to the effect that, well, you just put your finger in the air and you come up with a figure that you think is not too high and not too low. This person's been detained for 7 years unlawfully. What's a ballpark reasonable figure? Now, the difficulty with that, to my mind, is that one might easily get led astray. One might fail to take into account relevant factors, or one might take into account irrelevant factors. And unless one disciplines oneself in some way, how can one arrive at a satisfactory figure?
Well, I accept that is a good approach to the problem, my lord. If it's a criticism of the Court of Appeal's lack of reasoning, I would say this, that we're in the context where the judge had actually identified, she'd made findings of fact, she'd identified the important factors that bore on her decision, and I submit that the Court of Appeal was entitled to say, accepting all of that the judge has found and accepting her reasons, her figure is still inordinately low. Now, I admit that doesn't go all the way that your lordship would suggest, but I submit it was open to the Court of Appeal to do that. Because accepting the judge's findings and all the factors she finds important, and also accepting her reasoning on aggravated damages and on vindicatory damages, and deciding overall, looking at in particular at the previous award in the Bahamas, but also in the considering what, to the court's mind, is proportionate and cross-checking with other jurisdictions, 750,000 was an overall global sum. The difficulty might be, my lord, is that it is a very difficult task, and every case is different. And one is in part compensating for something that's intangible.
Did any of the comparable cases include serious assaults and battery?
Well, Takatoto does.
No, I meant I appreciate that one, but the other ones that the court looked at itself.
No.
And the other point that arises in relation to them is the comparable prison conditions in the jurisdictions of those awards and in the Bahamas.
Yeah, yes, I accept that, and I understand the points that my learned friend makes about those foreign cases, but all those points would go to, in the circumstances of this case, a relatively minor uplift. Remember that we are talking about an order of magnitude difference. They do not support the importance of the cross-check of those foreign cases, as I said, was, do other jurisdictions support the view that these awards are in the millions or the tens of millions?
Well, that's my point, because, I mean, if the detention conditions in the Bahamas are far worse than in those other jurisdictions, then there isn't really much of a comparison, is there?
But I accept that point, but it doesn't go as far as a 10 or 100 times order of magnitude in my submission.
No, I mean, here we've particularly got the assaults and battery side of it, which rather, following on from what my Lord Kitchen said, is maybe a point of difference from those comparable cases, and suggests that some process of identifying the constituent elements of the overall award may be helpful in the decision-making process.
Yes, indeed. Well, that probably takes us on to the assault and battery point.
Yes.
I think I've dealt with the, yes.
Can you just help me on this? When the first instance judge in this case refers, as she did, to inhumane conditions, I mean, I take that myself as and this perhaps is your assault and battery point in part, as including the allegations of, proven allegations of assault and battery. Yes. But do they go further? Did she, in her judgment, advert to the general conditions of detention in the way that
yes.
courts in Takitoto did?
Yes, I think we will come to that when I go through her findings on assault and battery.
Okay.
Because I think you can treat them as referring to both.
Okay.
In her final paragraph. Now, yes, the appellant said that it's to be inferred from the judge's judgment that she made no award for assault and battery, and the Court of Appeal failed to appreciate that. I think that's the summary of the challenge. Now, in my submission, that's wrong. I think the board already has the point that the appellant invited the judge to make a compendious award, and invited her to do so by choosing a daily rate which compensated for both false imprisonment and assault and battery. So that was the invitation. Compendious award, implicitly in these circumstances, means choosing a daily rate which compensates for both. And the judge took up that invitation. That's at page 125, paragraph 65. She refers there to the judgment of the Privy Council in Merson. Now, I won't take the board to it, but the board there said it's preferable to make a separate award for assault and battery, but it was also entirely reasonable to make a compendious award. So it was accepted for the judge that she could make a compendious award without transgressing the guidance in Merson. Now, when the judge made her compendious award, she started, in fact, just the paragraph before,
Sorry, could you give me a page number?
124.
124
Yep.
is started at, yes, so she took up the invitation at paragraph 65, page 125.
Sorry, where are we looking? Paragraph?
EP1.
I'm now going to the previous page, 124, where the judge starts by saying, Mr. Ngumi is entitled to damages for the torts of false imprisonment, assault and battery. So she's expressly saying that she is compensating Mr. Ngumi. And then she refers to her, she goes on to refer to her findings there at paragraph 62. He endured cruel and inhumane treatment. So he was kept in, this is an answer to my Lord Richard's question, he was kept in deplorable, inhumane and degrading conditions, and he endured cruel and inhumane treatment. So that's a reference to her findings about assault and battery and the conditions. She's there referring back to her findings at paragraphs 46 and 47, which are page 118. That's her finding of assault and battery, with reference to the evidence that she's already set out, beatings, physical abuses and injuries. And when she refers to the evidence she's set out, she's referring to paragraphs 22 to 25, which are at page 112. (22, 23, 24, 25), all are evidence of assault. So when the judge embarks upon the compensating exercise, she is expressly saying, I'm going to compensate for assault and battery. She's expressly referring to her findings about it. And then when she does so, that's at paragraph 89. When she makes her award, it's at paragraph 89. Page 133. And I say, in light of what we've already seen her say, where she says, I also took into account the aggravation suffered by Mr. Ngumi, which was nothing short of cruel and inhumane. She is referring to, amongst other things at least, the assaults. She did use the phrase cruel and inhumane treatment in relation to the assaults earlier in the judgment. So that's assault and battery. Oh, just
and
one
at
more.
90, she refers expressly to assault and battery.
Yes. Thank you, my lady. Yes. Just on one more point on assault and battery, the taper point, if I can call it that, my learned friend's taper point doesn't go anywhere. he says it's to be inferred from the fact that the judge tapered her award that she cannot have been making an award for assault and battery. That is false logic. If the compendious award includes an award for false imprisonment and assault and battery, and the judge decides to taper the award for false imprisonment, the award will be tapered, whether or not it includes assault and battery. There's no logic in saying that tapering means there cannot have been an assault component. You'll recall that the judge's taper in any event was a rough and ready taper. She took off a third. She didn't say the daily rate goes down at a certain time. Can I move on to the question of vindicatory damages? And in principle, the starting point when considering the award for vindicatory damages, or what the courts below call constitutional damages, has to be the Court of Appeal's award for compensation, or the Court of Appeal's global award. And that's because, as the board recently clarified in the case of JM, the vindicatory award is to be awarded, once considered compensation, is to be awarded if and only if one finds that to be insufficient to vindicate the breach of the constitutional rights. So in a case where the Court of Appeal has increased the compensatory award, the judge's decision whether her compensatory award was insufficient to vindicate the constitutional rights is no longer of primary materiality. It's useful matters for the Court of Appeal to consider if they accept that the factors identified by the judge were factors worthy of expressing public outrage, emphasizing the gravity, or deterring future breaches. But the judge's assessment that another $100,000 was needed, it depends on her compensatory award. And of course, the Court of Appeals increased that. So the starting point for vindicatory has to be the Court of Appeals judgment rather than the judge's award and any alleged errors of principle that she made. And that, just to give your lordships and your ladyship the reference in JM, that's in the supplemental bundle. That was a decision that was handed down in December. It's page 665. And the guidance on vindicatory damages at page 688. This is Lord Burroughs. Actually, the guidance begins 687, but I'm just going to refer your lordships to the third point that Lord Burroughs makes at paragraph 58.
What page is that, sorry?
Page 688 of the supplemental,
sorry. Yes, got it.
supplemental authorities.
Thank you.
Paragraph?
58.
Thank you.
It's only if compensatory damages are inadequate to vindicate the right and to achieve the other functions of vindicatory damages, the vindicatory damages should be awarded. This may be expressed by saying that it should be awarded if, but only if, compensatory damages, which may include aggravated damages, are inadequate to vindicate the right. So, as I said, the judge's total award of damages, excluding vindicatory award, was in the region of $536,000. She decided that was inadequate and added $105,000 to make nearly $642,000. Now, that assessment no longer applies when the Court of Appeal has increased compensatory damages. At least it doesn't directly apply. So now the Court of Appeal's award was something of a global award. We've looked at it before, but just to go back to it, it's page 376. Now, in that context, in the context I've just described about the purpose of vindicatory damages, this global award is a finding that $750,000 is enough to both compensate the appellant and to vindicate his constitutional rights. It may be said that reading the paragraph through, it could be said that the Court of Appeal's finding a compensatory award in the region of $650,000 to be appropriate and an additional vindicatory award of $100,000. Because they adopt $100,000 as the award of constitutional damages. Now, I accept that the Court of Appeal then maybe seemed to be appeared to take the approach of leaving the judge's award of vindicatory damages undisturbed. And indeed that they, earlier, paragraph 49, said the judge made no error of principle when in the factors she identified in the amount she awarded. So that might lead the board to ask itself whether the Court of Appeal is actually answering the question, because the question now for the Court of Appeal is whether an additional award is needed it's not whether an additional award is needed on top of the judge's award of compensation, but whether an additional award is needed on top of the Court of Appeal's award of compensation. So saying the judge was right, one might ask whether the Court of Appeal is answering the right question. But I would also say that the terms in which the Court of Appeal makes its global award suggest that it was carrying out the right task, because it's deciding overall, as it says, what sum was required to both compensate the appellant and vindicate his constitutional rights. And I would also suggest that when the Court of Appeal refers to the judge's findings on constitutional damages, as I said before, the relevance of that for the present purposes is that the Court of Appeal is agreeing that the factors the judge identified were factors which were worthy of expressing public outrage, emphasising the gravity of the breach or the importance of the right, and deterring future breaches. So that I would say it's fair to read the Court of Appeal's judgment as adopting those factors for itself when deciding what's an overall figure appropriate to vindicate the appellant's constitutional rights.
Subject to the increase that you're
Yes.
not actually accepting, but indicating it's hard to resist, to add on the bulk of the 3-month period at the start.
You might say that the Court of Appeal, if it added on, it might have decided that less was needed by way of vindication, but I don't want to second guess too much.
There's something very round about 750,000, isn't there?
Yes. But on the other hand, there's a degree of precision about 6 years, 4 months and 6 days of unlawful detention.
Yes.
The appellant made some criticism of the judge's approach to vindicatory damages. He didn't get the chance to go through them orally, but I think it said that because the judge didn't identify the specific phrases from Ramanoop, such as express public outrage, emphasize the importance of the breach, the judge wasn't taking those factors into account. I say that's not a fair reading of the judge's decision. When she identifies 4 particular factors which weigh heavily on her, sorry, I thought that must be closer to the end than I thought. When she identifies the 4 factors which weigh heavily on her, that's at paragraph 112, page 141. She's doing that having already recounted the authorities, which include full recitations of the Ramanoop criteria. And so she's not required to say, this factor in particular provokes a sense of outrage in me, or this factor in particular makes me determined to emphasize the gravity of the breach. She doesn't need to expressly use the phrases from Ramanoop to be carrying out the Ramanoop task in my submission. When I say that she's referring to authorities which expressly recount the Ramanoop criteria, I mean in particular page 140, where she talks about paragraph 108, where she refers to paragraphs 21 to 29 of Innis. So she's read paragraphs 21 to 29 of Innis, and they include a verbatim recitation of the Ramanoop criteria. If you want to see it, the note is, the reference is 1819. Page 1819 is those passages from Innis. So I say there's no error of principle in the way the judge approached vindicatory damages. I'm moving on now from damages to the other points made, the other grounds of appeal. Starting with indemnity costs. I think the simple answer to indemnity costs is the House of Law's decision in Furry and LaRue. I've referred.
You might have to turn a key in that particular lock before it becomes simple.
Well, just to go to Furry and LaRue, and well, let's start with Arrowett Homes actually, because this is the board talking about its role in costs. That's at page 1661. This is the Bahamas case.
Yeah.
And the question on costs. Cost is dealt with at paragraph 50, which is page 1677. I won't actually go through the particular cost issues in that case. I'm really going to emphasize the last sentence in that paragraph. So there's the board's general reticence on costs, absent any alleged error of principle. And no error of principle is alleged in this case. What's alleged against the judge is that she was factually wrong in deciding that the conduct of the state was not egregious or contumacious. My reliance on Fourie and LaRue derives from the fact that that was a case where the House of Lords discussed the question of indemnity costs, and specifically whether conduct could be said to have merited an award of indemnity costs in circumstances where all their lordships expressed grave reservations about the finding that the conduct had merited indemnity costs. But despite expressing those reservations, the 4-1 majority declined to interfere with the award on the basis that it wasn't a matter for the Second Appellate Court. So that's Lord Scott's approach is at page 1794, paragraph 40. So Lord Scott found it difficult to identify why an indemnity order had been made. Indemnity costs order, I should say. But having then adverted to perhaps the wider flexibility under the CPR, he goes on to say, in the present case, the Court of Appeal has affirmed the Deputy Judge's award on the ground that no error of principle could be discerned. I do not think the Lordship should interfere. And it's Lord Carswell at 1796 who makes the point more explicitly. Paragraph 49. Again, I also have reservations. I find it hard to see any sustainable ground on which such an order should be made. But it goes on to say at the very last line of the page, I agree with Lord Scott, however, that this is peculiarly an area in which the principles should be developed and applied by the judges at first instance, with the oversight of the Court of Appeal, and the House should not reverse a costs order without a strong reasoning principle. Now, in this case, the judge was invited to make an indemnity costs order, but by the way, without all of those individual points that are now identified to the board and were identified to the Court of Appeal. She was invited in general terms to say the conduct of this litigation is deserving of indemnity costs. And she said it was not. She'd found that it was not. It did not cross the threshold. And the Court of Appeal found that she made no error of principle. Indeed, it wasn't suggested that the principles she had cited were the wrong ones. And so I submit this is not a matter where the board will interfere. The assessment of the conduct of the litigation in particular was preeminently a matter for the judge. On the question of interest, I'll do no more than refer to my written case because there's...
Are you coming back to the costs in the Court of Appeal?
Yes, I will. Let's do that first then. If you for cost then costs, and interest last.
Because there may be a point of principle here, and they haven't been upheld by a higher court yet.
Yes, I do not say that there's a point of principle in here. This was well within the Court of Appeal's discretion, the costs award they made. They had written submissions from both parties on the question of costs. The Court of Appeal gave a careful written judgment, which is at page 512. 512.
They found that the appellant was not the successful party.
Yes.
There'd been no payment into court. He'd succeeded in increasing the level of damages by in the order of $250,000.
In the order of about 100.
If you include
Yeah, we include the interest. It's
Oh, yes. Okay, yes, that's right. No, I accept he had increased the award and there hadn't been a payment in.
What's the sustainable basis for saying he was not the successful party?
Well, when one consider all of his grounds and all of the issues upon which he failed.
But he was not awarded costs on an issue by issue basis.
Well, I'm not sure that's right, actually, because the Court of Appeals said, for example, when the Court of Appeal was invited to find that the issues on which the appellant lost were not important, such as the indemnity costs issue, the Court of Appeal said, no, well, I don't accept that wasn't an important. I don't accept that didn't take up time.
Where is that?
That's right at the end of the cost judgment. Paragraph 24. This is page 521.
Yes.
In addition to the issue,
The observation in Bolton was presumably one about the old rules of the Supreme Court.
yes, and
Now, what are or were the rules in the Bahamas?
they are the old rules of the Supreme Court.
Oh, so they haven't gone to a form of CPR.
I think very strictly that there is now a form of CPR in the Bahamas, but perhaps at this time it was the old rules of the Supreme Court. Oh, no, it hasn't. I'm remembering, it hasn't been brought into effect yet, is it?
Hasn't come into effect.
No, okay, sorry, half memory.
So it wasn't the CPR type of rules at this stage.
No.
The primary factors in the Court of Appeal's mind seem to have been the $11 million that he was asking for, and the
Yes.
interest.
Yes. Now, the $11 million, it's not simply, of course, you could say that the appellant asked for $11 million and at least got more than he'd been awarded. That's one way of looking at it. But another way of looking at it is, in that asking for $11 million were a number of arguments advanced that failed. The argument that you should adopt this formula approach, the argument that aggravated damages should be in the sum of $1 million, the argument that exemplary damage should be in the sum of $5 million, those arguments were all advanced before the Court of Appeal and failed. Now, I could... I won't go to the appellant's appeal submissions, but just to give you the reference where they start, it's page 189. But not succeeding on $11 million includes losing the appeal on aggravated damages, losing the appeal on exemplary, losing the exemplary award, in fact, because the judge wrongly made an exemplary award and a vindicatory award, when the appellant was contending for a $5 million award. So when the Court of Appeal says the appellant, we have to remember the appellant was seeking $11 million. Unpacking that, there are a number of issues and a number of arguments that failed. And
the indemnity costs appears to have been another major issue in the Court of Appeal's mind.
yes, plainly from the Court of Appeal's judgment there. And that Court of Appeal is entitled to assess how things played out before it. And by the way, the board's reasoning in CPSAD and PSAD, which the appellant now asks the board to accept, shows that the Court of Appeal went wrong in principle, was cited by the Court of Appeal. The Court of Appeal had that in mind. That's page 519. Paragraph 21. And that was a case where the board overturned a decision of the courts below as to who was the successful and unsuccessful party. in particular on the basis that the event was the obtaining of damages. The Court of Appeal understands that to be a strong argument in favour of saying the appellant won, but nevertheless, in the circumstances of this case, decides that the appellant cannot be called the successful party. So I would submit that the Court of Appeal is not misdirecting itself as to law, because it has in mind the very principles that the board expressed in Super 7%.
I suppose when you were asked about how could they say the appellant isn't the winner of the appeal, paragraph 7 of their costs ruling, they have identified elements of success for the appellant, but also points on which he had lost. And in paragraph 18, page 517, they're talking about if there's no clear winner of an appeal, the proper course may be to make no order for the costs.
Yes.
So it's not that they've disregarded the fact that there has been success.
Indeed, yes.
And again, at paragraph 22, page 520, it's unrealistic to hold that the appellant was successful overall in this appeal. Again, they seem to be looking at the points on which they won and the points on which they lost.
Yes, I don't think I could add to those observations. So that's what I have to say about costs in the Court of Appeal. So finally, interest. And really, I made only 2 points in my written case, and they are that, first of all, it was open to the Court of Appeal to award damages from the date of the writ. The power is in the Civil Procedure Award of Interest Act, and interest can be awarded on the whole or any part of the debt, or damages for the whole or any part of the period between the date when the cause of action arose and the date of judgment. So that includes the date of the writ. But in this case in particular, the Court of Appeal was offered the choice of from the date of the cause of action arose or the date of the writ by the appellant in his submissions. The appellant proposed awarding interest from the date of the writ in the alternative. So I find it hard to see why that should now be described as an error of law by the Court of Appeal when it was proposed to them by the appellant as an alternative.
And sorry, do you have a bundle reference for that?
Yes, that's page 252, paragraph 200. Yeah, the only thing I would add to my submissions on interest is that if one were to award interest from the very first date of imprisonment, then one is awarding interest on all 3,000 odd days.
You wouldn't ordinarily award interest on an accruing sum.
That's my point, yes.
Otherwise than by reference to some table of accrual. I mean, the alternative is sometimes a fudge of awarding it halfway between the date of the accrual of cause of action and the date of the writ, which is almost always a fudge, but quite often the convenient one.
Yes, that fudge would have been open to the Court of Appeal. It wasn't proposed to them by the appellant, but it wouldn't be wrong to simply choose the date of the writ as well. It was within their power, and there's no error of principle. But I would say it's...
Here the writ was here the order was for interest on the whole sum, wasn't it?
Yes.
Yes.
It can't be wrong because it can't be an error of law on the part of the Court of Appeal when it was proposed as a lawful choice by the appellant. That's the simple answer in my submission. So unless I can assist the Lordship's
Could I just... Okay. Just going back to the general damages and the sort of taking account of damages for personal injuries, which is referred to by Lord Wolfe in Thompson. First point, is it referred to in any of the other cases that we've got that's before us?
Not that I have, not that I'm aware of, but I couldn't answer.
No, I understand. But the second point is, I haven't got the page reference, but when he refers to that, he is referring to it in the context of damages for a short period.
Yes.
And the difficulty, I think, comes in extrapolating it to damages for unlawful imprisonment for 6 years and quite how one takes account of awards for personal injuries.
Well, yes, I mean, one can think of awards for personal injuries which are time-based, but they are in circumstances of, well, you're talking about suffering over a period of time, aren't you?
I suppose that might be. I suppose if someone was
directly comparable, but
sorry.
Yes.
You can say if someone was incapacitated to a significant extent over a period of 6 years, then that might provide a sort of yardstick for simply for unlawful detention. You'd then have to perhaps also factor in the assaults and all the rest of it as well, but that might provide some yardstick.
I mean, just on that, I mean, you could get pain that continues over a very extended period of time as well.
Or disability, yes. I would say it's maybe also useful in the sense that it considers the expectations of society, litigants, courts about what kind of damages damages ought to be awarded. Because you can see references in the arguments here to why aren't we more like Florida? And the judge says we're not going to be like Florida. Like Florida.
No. And an award of, I mean, what you don't normally have with personal injury awards is the deliberate infliction of harm. I mean, it's normally a negligence action. Here, you've got unlawful detention by the state. But perhaps that's recognised by the aggravated damages and by the vindicatory damages.
I would say so, yes.
Yes. Yes, thank you.
I was wanting to ask a question about the rate of interest. What rate of interest was applied in the end? Sorry, I should know the answer.
6.25%.
And how was that derived? Is that a judgment rate or?
I might have to ask my own.
Right.
Judgment rate.
So that's the equivalent of our judgment.
Yes.
Judgment debt rate. Is that right?
Yes, and it's not an unusual practice in the Bahamas and indeed in other Caribbean jurisdictions to use that as the damages rate as well.
Right. Okay.
So it was a high rate for that period.
Yes, it is a high rate.
Yes.
Thank you.
Thank you. Yes, Mr. Smith.
Thank you, Lord.
Don't feel you have to take up the whole of the 25.
I don't feel that I have to, but I may take up a little bit. Thank you. Just to deal with the last point, which my Lord Richards raised, my friend answered. If one were to simply look at the Merson award for constitutional damages that was upheld by the Privy Council, which was $100,000 back in I think it was 1994. And she had, I think, a 2-day ordeal where she was not beaten. She was kept in an unsanitary cell with many other prisoners. it is almost impossible to rationalize how a constitutional award or a punitive award sends either vindicates or sets an example to the executive to deter them or to express the outrage of the public at the kind of behavior that Mr. Ngumi was subjected to. And the Merson one is actually a fair comparator, because that is the figure of 100,000 which was alighted upon by the judge at first instance and seems to have been accepted by the Court of Appeal if that is factored into their award. And it is, we submit, wrong in principle, unreasoned, and perverse to make a finding decades later that that same award of either vindicatory or punitive, whichever, or exemplary, whichever, exemplary and punitive, or vindicatory, can be sustained on principle at 100,000 or 105,000, as I think what the court found for Mr. Ngumi. Mr. Ngumi was, and that is the submissions we made at the Supreme Court on that point were quite lengthy, and in the Court of Appeal, that, and hence the request for a high figure, because there are so many cases, which we refer to in our submissions, where despite judgment after judgment in which the actions of the immigration and or police are shown by the courts to be unlawful, the awards have never been sufficient to teach them a lesson. And so Mr. Ngumi spent 5 months in a hospital after his release, suffering from tuberculosis. He was detained for 6.7 years in the most appalling conditions, which were described by the judge. Ms. Merson spent 2 days in a cell in a jail in Freeport. And Mr. Tynes, for half a day, I believe, received, in the Tynes versus Barr, I think he received $100,000. That was set aside by the Court of Appeal because it was said to be duplicitous. And there was no appeal by him, but there was an appeal by Ms. Merson to the Privy Council, which upheld the $100,000 award. And so there is a comparator in the Bahamas for constitutional or vindicatory damages, sorry, constitutional or punitive damages. And it simply, I would submit, baffles the mind. There's no rational reason why Mr. Ngumi, with what he suffered, should receive simply $5,000 more than Ms. Merson or Mr. Tynes. Yeah, 30 years later, I'm reminded by my friend. I mean, even if one were to, increase it by way of inflation, cost of living, or some factor, it should have been dramatically increased. We submit that in and of itself ought to suggest to the board that the matter should be remitted to properly compute or properly consider on a rational and reasoned basis what the award for constitutional damages or exemplary damages should have been. I'm not going to repeat the things that I referred to in our case, but on that simple point, we say that just on constitutional damages, inhuman and degrading treatment, arbitrary detention under Article 19, the inhuman and degrading under Article 17, those damages should have been extremely higher than Tamar Merson or Harvey Tynes. So going to some other points, my friend has suggested that we accepted at the Court of Appeal, and that it is not open to us to argue that there was no recommendation because of the finding at paragraph 33 of Justice Charles's judgment that the magistrate had recommended deportation, that we did not expressly dispute it. But as we said in our case, we did not contest the fact that a recommendation for deportation may have been made. It was an order, in fact, for deportation. But there was no finding by the judge or the Court of Appeal that it was a recommendation to the Governor General under Section 41, subsection 4. At that stage, the issue was whether the magistrate had the power to make the deportation order that she had purported to make, not whether there was some other power under Section 40 to recommend deportation for the second limb of subsection 41(4). At that time, the respondents were not arguing, they didn't raise it at the Supreme Court or Court of Appeal, that the recommendation was under Section 40 or Section 40, subsection 4 purposes, which made the detention legal. And I'd like the court to go to EB 68, which EB 68 is the defense. Oh, 68, where is it? EB 68 is actually the submissions. So nowhere in...
Sorry, submissions at what level?
At the Supreme Court by the defendants. EB 68. And that submission at paragraph 26 was simply, the defendants submit that the detention of the plaintiff was legally justifiable as the relevant statute provides the legal framework to detain persons whom it is reasonably believed are residing in the Bahamas illegally, unquote. That was the extent. There was no debate either in the Supreme Court or in the Court of Appeal about whether the recommendation or the order or the sentence was one that was made under Section 40.
If there was no debate in those courts, and bearing in mind that the respondent has abandoned almost all of its opposition to the removal for 3 months, and it's down to about 4 days, I think, well, why should there be a debate about it before us?
Should I stop?
I think there are more important things to concentrate on.
I will. It's just they persisted on the recommendation point, my lord. I agree. So moving on. The respondents, this is a point on reliance upon other, the respondents in their case at paragraph 9(7) EB. They submit that, quote, it was not perverse of the Court of Appeal to cross-check with other jurisdictions. And they repeated this in their oral submissions again a moment ago. And as my Lord Richards pointed out, conditions in this case may be and were in fact possibly very different from conditions in the prisons and the whole process of detention in the UK. So it was not a mere cross-check, we submit. That was the start and end of the analysis. They simply referred to these other cases, again, without giving us the opportunity to comment or make submissions on them. And we say and emphasize that the Court of Appeal, in deciding to set aside the judge's award and come to a global figure, ought to have first considered Bahamian authorities first. And as was done in Arcari, as was done in Scott, as was done in Karachan, as was done, and all of these, my friend indicated that there were no personal injury decisions, but in fact, in the bundle of authorities, I can give your lordships just the EB reference for the personal injuries case. Arcari is at 1114. Scott is at 1868. Chan is at EBS 91, that's a supplemental bundle. And Matuzevich at 1399. And the appellant has never contended that we should look at Florida or the United States for comparable awards. And we do not do so here either. We say that when one looks at Bahamian awards, they have been generally higher, even for the long-term detentions. And there were two cases where a daily rate was used. That's the case of Bojang at EB 1451 and Amishir at EB supplemental 408. Even after Ngumi, one by Justice Charles herself and also by the registrar in Amishir, and also by the Chief Justice, who applied a daily rate in the Martin Orr case. What's the reference, please? Martin Orr at $975 a day. So there is precedent in the Bahamas for long-term detentions. That Martin Orr is at 1384. And Dexter Davis. And what's the reference, please? Dexter Davis. 1250 is the reference. Another point in reply to my friend is when he made the submission, and it's to be found at paragraph 89, he says that the reference to inhuman and degrading treatment was a reference to assault and battery. We submit that it was not. At paragraph 89 of the judgment, which is at 133, the ladyship, quote, said, "The aggravation suffered by Mr. Ngumi was nothing short of cruel and inhumane," unquote. And that is obviously, we submit, a reference to the assaults and batteries. But at EB 115, paragraph 34 of her judgment, she went to make an additional point in respect of which we do not see or can discern an element of any damage having been awarded. She said, quote, "I find further that Mr. Ngumi was badly beaten on several occasions at the detention center. He was also subjected to cruel, inhumane, and degrading treatment, so much so that he developed health problems, and at some point he contracted tuberculosis and scabies." Accordingly, we submit, when the judge at EB 133 took account of aggravation suffered by Mr. Ngumi, which was nothing short of cruel and inhumane, this was her finding, and she ought to have increased the damages, and so should have the Court of Appeal, for constitutional breach in Article 17. The assaults and batteries, which we found earlier in her judgment, were separate and apart from the instances of cruel, inhuman, and degrading treatment, which were breaches of Article 17 of the Constitution.
But at paragraph 62, page 124, seems to be finding both that the assaults involve inhumane and cruel treatment, and that the conditions did. So when later she's referring to inhumane paragraph 89, page 133, she says the aggravation suffered by Mr. Ngumi was nothing short of cruel and inhumane. Isn't she referring to both elements, just as a matter of reading her judgment?
I would submit, no, my lord, because in paragraph 34, she distinguishes it and finds separately that in the absence, I further find that Mr. Ngumi was badly beaten on several occasions. I just read that to the court.
Yeah. Well, in 34, she doesn't say brackets, but that's not cruel, inhumane, and degrading. She just doesn't characterize it there, but she does it in paragraph 62.
Yes. Let me, yes. What's that page? 119. No, I'm looking for inhumane and degrading treatment. Yes, at paragraph 49, my lord, at page 119, as to Article 17, she makes a separate finding that in light of the facts which have already been detailed above, I conclude Mr. Ngumi endured cruel, inhumane treatment whilst at the detention center and is therefore entitled to damages. That is a separate element of damage we submit that Mr. Ngumi should have been compensated for, not just lumping it into assaults and batteries. And in our case, we set out the differences between the assaults and batteries and also the inhumane and degrading treatment. That's, yes. Sorry.
It's my fault, but I'm not sure if I've quite followed the point you're making on paragraph 49.
I'm saying, I'm trying.
I mean, paragraph 49, the judge concludes that Mr. Ngumi endured cruel and inhumane treatment, so that seems to be a sort of general expression.
But before that
covers both the conditions and the beatings, doesn't it?
But before that, in paragraph 48, she's specifically dealing with Article 17.
Yes.
Which is different from assaults and batteries.
It may, the assaults may have involved a breach of the constitutional rights. The conditions of detention may have involved a breach of the constitutional rights. Indeed, the judge found that they did, both of those things.
Yes.
So it's my fault.
The point that I'm making,
what point you're making?
The point that I'm making, Lord, in reply, is that one cannot discern. When one looks at the award of $105,000 and compares it with Merson and compares the abuse and inhumanity that Mr. Ngumi was subjected to, there's no reasoned basis upon which an award of $105,000 can be sustained for constitutional damages, because there ought to have been a separate element which she married into false imprisonment, assault and battery. And also, arbitrary detention was an award that Ms. Merson got and Mr. Tynes got 30 plus years ago. And there can be no comparison between a half a day for Mr. Tynes and 2 days for Ms. Merson, with 6.7 years for Mr. Ngumi. It is inordinately low, whether you take it from the judge at first instance or when the Court of Appeal wraps it into the $750,000. We submit it's unsustainable. And coupled with that, and I had promised, my lord, to refer you to, let me do that now, if your lordships just take a note at EB 113 and EB 114 is the pleading letter from Mr. Ngumi. It's quoted by the judge in full at paragraph 28 of her judgment, EB 113 and 114, in which describes, my name is Mr. Ngumi. I'm writing this letter to request your assistance in solving my problem with basic needs. I was released from the detention center on August 4th. I was detained from 11 January, where I would have been there for 6.5 years. As you know, most of the people who were my friends would no longer be friends, out of sight, out of mind. Therefore, I'm asking if you would issue me with some kind of paper in writing which would give immigration allowance to me to have some income so as to provide to any employer that is willing to hire me temporarily. It will assist with me police questioning, I would then be able to afford basic necessities such as food, clothes, hygiene products, housing. I also suffer from hypertension, so I'd be able to purchase the necessary medication. While I'm trying to get a passport, I cannot afford to pay for one to come from Africa without any income, which was not even, unquote, answered by the immigration authorities. And one goes back to Tynes and Merson again, where the issue of an apology was, you see, in Merson, Her Ladyship, Justice Sawyer, as she then was, her judgment was upheld in the Privy Council on the damages and on the constitutional award.
But I don't think the amount of the damages was an issue before the Privy Council. It was whether they should have been awarded at all. The quantum was not an issue.
Lord, I would like to say maybe, but my recollection is that the lordships of the Privy Council found it was neither too low nor too high.
Well, we can check that.
Okay. Yes, please. So, Her Ladyship was very precise. And by her precision in her judgment, it was a very long judgment at first instance. And when it got to the Privy Council could see her reasoning and could therefore rationalize it. And I believe we'll find it. So, but in this case, it's the complete opposite. We have a judgment of the Court of Appeal, which we submit should be set aside, because it is so imprecise. We have really no way of knowing. And it provides no guidance to the courts below or to practitioners, et cetera, as to how that sum is made up. And we say that it is lacking in reason and any principled approach, and should be set aside and remitted for reconsideration. So that's, so.
I think we're just about on for a time limit.
Yes. So in the Court of Appeal, my lord, on costs, we set it out in our submission. And counsel, a judge is a judge and jury in our jurisdiction. We don't have trials. We can ask for any sum that we want by way of damages. And I went to great pains to express why the compensatory and the punitive, and at that time constitutional damages should be a lot, because of the behavior of the executive authorities. And the mere fact that we asked for more doesn't mean that we lost the case. We increased the award at the Court of Appeal. And indeed, when one looks at our EB 171, at 171, it's our grounds of appeal. We asked for it to be increased to the 11 million, but we said, or such other increased sum as the court may determine on the appeal. So we won our appeal by getting the sum increased. And ultimately is who pays the check at the end of the case. And the respondents would be paying an increased amount, which was obtained at the Court of Appeal. Unless there's anything further.
No, not. Thank you.
Finished on the job.
Well, we are most grateful to all counsel for the oral and written submissions. And the board will take time to consider what advice to tender to His Majesty.
Thank you.